There you go.
Okay, so obviously the topic of workplace harassment and violence, it is a huge scope. And so I have put a lot of material into the PowerPoint, so don't be scared when we open the slides. I've actually just put most of it in there so that you have access to all of that information after the event. So we won't go through all of the material that's in here, but first I'll just introduce myself. So I'm Melissa. I am a health and safety officer with the Federal Labor Program. So as I was mentioning earlier in the panel, if you are working for a First Nation itself, then you would likely attract federal jurisdiction, and this would apply to the employees working for the nation. Other entities gets a little kind of messier in terms of business development corporations and all that stuff. But if you're working for a nation itself, then this is going to apply. So I will first, just maybe we can go to the next slide. So I will just mention, in case you guys don't know, so there has been a provision for workplace violence prevention since about 2008 in the federal legislation, which came before that of the province. And so we actually have a change. So until January 1st of this year, we were dealing with Part 20 of the Canada Occupational Health and Safety Regulations. And now that is only going to apply if you have an incident where you have had a workplace violence incident reported to you before January of this year. Anything that comes after January of this year, there is a whole new regulation. And so under the Canada Labour Code Part 2, the enacted regulations are the Workplace Harassment and Violence Prevention Regulations. And it is a complete overhaul of what the legislation used to be. So there are a lot of new kind of duties that the employer needs to know about. So I'll just go into some of that. And please feel free to ask any questions, just pop in as we go. And I will try not to bore you to death because I know that this is really, really dry and yet complicated stuff. Okay, so maybe we can go to the next slide. So there is a new definition of harassment and violence. And so it's important as a representative for the employer that you know what the definition is. So it's any act, conduct, or comment, including of a sexual nature, that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to an employee, including any prescribed action, comment, or conduct. So one thing to note now is that sexual harassment was not included specifically in the old legislation for workplace violence. And now it is specifically included. So an employee can choose to follow this process if there is an incident of sexual harassment, as well as going through the Canadian Human Rights Commission. So just something to keep in mind. So some of the changes have actually added some process burdens onto employers at this point. So I am just going to go over to the next slide. And again, most of the information I have in here is just so you can access it afterwards. So there are a whole new set of kind of definitions and roles underneath this actual legislation. And the employer has a duty to appoint a number of people. So there is now a requirement for a notice of occurrence. And this is to prevent someone from coming to file a complaint with us and saying that they told the employer and the employer didn't do anything. Now there's some actual information that has to be shared. So if there is an incident of workplace violence, the person that was the subject of the incident or a witness can file a notice of occurrence with the employer. And that can be done in writing or orally. They've specified that the principal party is the person who is subject to the harassment and violence. The responding party is the person alleged to have being responsible for the occurrence. An applicable partner will be your safety committee if you have one. So if you have 20 or more employees, and if you don't, then it would be your health and safety representative. And if you ever have questions about the safety committee stuff or anything like that, please feel free to reach out to me and I'm happy to walk you through some of that. So I just want to, one of the changes that you really should be aware of is that now the legislation allows an employee to file a notice of occurrence with an employer within 3 months of ceasing their employment. So you can have an ex-employee bring up one of these notices and it would still prompt the employer to have to investigate if it met the definition of workplace violence and harassment. So just something to keep in mind. And there is actually a provision where they can be allowed extended period of time after that 3 months as well. So kind of dealing with the whole concept of addressing lateral violence and workplace violence and dealing with all of those things ahead of time will be beneficial to try to prevent these kind of after the fact complaints coming in. Okay, so we'll go to the next slide. So again, there's just a couple more kind of people that you're going to have to sort out. So the employer has to designate a recipient for these notices. And that recipient has to be trained in kind of their role. So again, so you're going to want to be looking at who would best be the kind of designated person. If that's you as the HR representative or you as the band administrator, you're just going to have to look at that. It can also be a third party if you have a third party that's available to do that. There's also a person designated. So that is someone that's going to be the person that receives contraventions if there's any legislative violations. And so that's also someone you're going to have to select as the employer. Okay, we can go to the next slide. So this is an important part. So there's a little message in the chat. Sorry, what is designated? So person designated is going to be a person designated by the employer to receive complaints. So that is going to be the person that if say you have in the workplace, maybe the designated recipient is the HR person, and maybe that HR person might not be the best person to be dealing with all of the complaints. It might be important to have a secondary person available. And that might be if the person is maybe filing a complaint against the designated recipient or something like that, which is still a bit tricky. So it is specified in the legislation, and that role does have to be kind of filled as well. So it does say in here that the point of appointing someone as the designated recipient, you need to ensure that that person is not going to be violating any kind of privacy or confidentiality concerns. And you do want to have the two different parties as required. It doesn't say that it can't be the same person in the legislation. So I think that you would be able to, as long as it meets the requirements under the two sections. So it doesn't say that it can't be. So you might be able to do it. So hopefully, Valerie, that answers the question. Okay, and so for workplace assessments, so one of the requirements is that you have to assess the workplace for all of the different kind of components of risk. So you need to do that now as an employer with the applicable partner. So that's going to be your safety committee or the health and safety representative. And so this is going to identify risk factors that will contribute to harassment and violence. This might include when you have sections of, say, receptionist, or you're operating a medical clinic or something like that on site. any kind of time you're dealing with the public, or if there's known issues between different employees where harassment and violence might come into play. These are the things you're going to have to look at. And based on the risk factors you identify, you're going to have to implement mitigating measures to these risk factors. So if that's going to be having a little alarm for the person at the front desk in case something happens, or making sure that they have a way to get out of that space if something were to happen, all sorts of things. And this assessment has to be completed every 3 years, or when the risk factors have changed. You also have to work with the safety committee to review and update, if necessary, the assessment if you have a notice of occurrence, so an incident that happens where the responding party is not an employee. So if you have a member of the public who comes onto your site and is responsible for an incident of harassment or violence, you'll need to look at your assessment to see if you've missed something that you can do to fix the issue that had happened. And also if the principal party ends so the person who is subject to harassment and violence ends a resolution without any kind of, without the issue resolved. So you would also have to look at it there. And I know that there's so much information here. I do know that, and it's overwhelming. So absolutely, like I said, feel free to reach out kind of after this, and I'm happy to kind of go into more depth so that you have a more clear avenue for kind of going forward. So on the next slide, we have a prevention policy. So I'm sure that all of you currently have either a harassment and bullying or a workplace violence prevention policy already in place, because the legislation has required that for quite some time. But the new requirement for the prevention policy actually is quite different from what the old requirement was. And so this specifies a whole number of components that you have to have within that policy. And it also is going to outline who those designated parties are. So the person designated for receiving complaints, the person designated for receiving notices of occurrence, all of those things. So this is something you're going to need to look at. And this is the first step. So doing that assessment and getting this policy in place is a requirement, like as soon as you can. So this law did come into place in January. In the resource material, I have included some sample policies and that kind of thing. But this is where all of the kind of complaint handling comes from. So you're going to want to make sure that this is done as soon as you can. This also must be reviewed every 3 years. All right, and so training. So there is also now some specific training requirements, but they have provided some kind of leeway for making sure that you have time to take care of the training. So for any current employees, you need to train them on this process and this law by December 31st of this year, and every 3 years after that. The persons designated and the designated recipients, they need to have training before they assume their duties. So you'll have to make sure that that's done as well. And then new employees, it's supposed to be within 3 months of starting employment. So this is something that you're going to want to kind of get started on. I'm just thinking if there's anything else I can kind of add into this one. So just, you can use online training tools. So like the Canadian Centre for Occupational Health and Safety, they do have some online training. And if you choose to use that, that's fine. But you still do have to make sure that people are being trained on your kind of specific work site issues. So you might have to add something in on top of any kind of online training you select. Okay, and next slide. So I'll just mention there are new reporting requirements for harassment and violence. This includes if you are made aware of a fatality from harassment and violence in the workplace, whether it was an assault, or if this is going to be suicide or something of that nature. So this is something new. And there is also an annual report, which they have made due on the same day as all of the other annual reports that are due. But the spreadsheet is not available yet. The first time it's due is next March. Okay, so we will go into the next slide. And so this one is part of the process now requires that the employer provide monthly status updates on the complaint process. And so this is just something that's going to keep the process moving. So one of the things we often see when complaints are filed with the labor program for workplace violence and harassment is that the person has provided notice and nothing happens. And so this is a way of kind of making sure that there is constant action and that the actual file is kind of progressing. And so this is supposed to be done every month. Okay. This one just goes into, we'll just change to the next slide. I think I've covered quite a bit. So this is just some instructions for what to do when you receive a notice of occurrence. And Joshua and I are kind of sharing the time. So I'm just going to kind of leave this instruction with you. I won't go into that. And then the next slide is selection of investigators. So one thing you'll have to keep in mind is that one of the changes now is that the respondent, the responding party can't be the one filing these complaints any longer. So under the old legislation, they could, and they had input into the investigator, and now they don't. So now the kind of rights are lying with the principal party, so the person who was actually subject to the event. So there's a list of investigators provided on the Canadian Centre of Occupational Health and Safety's website. You can also use investigators that you are comfortable with, that you're just going to be able to provide the investigators' contact information and how they meet the requirements for doing these investigations. If the person goes with conciliation or something like that, it might be an elder or someone within the community that might be better to kind of walk through that process. We'll go over to investigation. So I have in the next 3 slides, there's a flow chart, which again, I'm not going to cover, but I've given the material so that you can use it. So there can be a number of avenues for resolution under the new legislation. And so that's going to allow for negotiated resolution with an investigator, conciliation, which is a much less formal process. There's a number of avenues that the principal party, the person subject to the event, can choose for this resolution. So it's also kind of an added burden from what it used to be, where it was just kind of one level. And now the person can ask for these different levels happening at the same time. So it's just something that you're going to have to be aware of kind of going forward. And I'll just quickly flash through the next slides just to briefly show you. So we have a flow chart of what you're going to do when you receive the notice, what the options are for how it's investigated. It's all kind of laid out here. And we can go to the next one, which just kind of goes into each section. And the next slide. And the next one. Sorry. And then the next one. So it's all kind of laid out there for you if something does come up. But I can tell you right now that it's probably going to be easier for you if you just contact us and we can kind of walk you through if there's any questions. So now I've provided these additional resources. So we have a sample policy. I see that Joshua is listed here, that you can reach out to him as well if you are needing to develop that policy. We have the actual regulations is linked here, the risk assessment tool for doing that workplace assessment, a sample user guide, requirements for employers, and then in the, I can't remember what they called it, that the, or something tail or something, where they have all the other resources. I've also included a number of resources in that section as well on top of these materials. Okay, so I think I am almost done. Okay, so this is kind of what I think is the most important thing to keep in mind. So although we are a regulator, we are absolutely happy to answer any questions. And if you call in with a question, there is no kind of repercussions for doing so. So if you call into the 1-800 number, it's our job to answer your questions. So we are absolutely happy to walk you through this process. So the 1-800 number is our general line, and you should hear back from one of the health and safety officers, usually within the day. If you have any specific questions and you would rather just contact me, my contact information is on here. And one other thing I would like to just quickly mention is we do information sessions. So this kind of thing, but tailored to the needs of your workplace. And it doesn't cost anything. So outside of COVID times, we travel the province, we work BC, Alberta, and the territories. So we are happy to go to your work site or provide one of these sessions virtually on workplace violence, on safety committees, on anything that falls under the occupational health and safety legislation. So I would for sure suggest that if you are experiencing anything where you're not quite sure what jurisdiction you are, or you're looking for more information on how to deal with something within the workplace, please feel free to contact us and ask us. We don't cost anything. And we're happy to provide that service in a way that will meet the needs of your workplace. So just absolutely keep that in mind kind of going forward. And then that is the last slide. And so I know Joshua is also going to be presenting some material. And then I'm not sure if we're doing kind of questions now or if we should wait till the end. Not sure what anyone's preference is, but if there is anything, you can put it in the chat or just ask. I'm happy to answer. If I haven't put everyone to sleep with that, that very dry topic.
Well, thank you for that, Melissa. I don't think there's, or at least I don't see any more questions coming in through the chat. Although Valerie, I saw that you're.
Yeah.
Do you have a question?
I do. Can you hear me? Oh, sorry. Hold on. Can you hear me now?
Yes.
Yeah, perfect. So Melissa, I'm so glad. Thank you for the presentation. I also sent you an email prior knowing that you were in this group chat. So, and that might seem redundant, but I had a couple questions. The first one is often, HR oversees departments that you wouldn't in another organization. And one of them is a school in our nation. Sorry, I should probably say I'm from Little What Nation, the HR manager over there. And then, so it's a bit particular when it comes to perhaps bullying or harassment, workplace investigation, when a child is somewhat involved, because, it does kind of follow also under the BC teacher regulation. So do you have experience in that process and your perspective that, you could shed some light on that wasn't covered in the presentation?
Okay, so the school can be pretty tricky. So like you said, it is a tricky circumstance. If the school is run by the nation and has involvement by the council, then it might still attract federal jurisdiction. So if it is that circumstance, one thing to consider is that for the workplace harassment and violence regulation, it says that if the, say, your employee was assaulted by a student or bullied or harassed by a student, that is not an employee who is the actual responding party. So, so it would stop the investigation requirement from our side of things. So it has to be an employee. What can happen is your employee might still file that notice of occurrence, and that will only prompt the employer and the safety committee to do a review of the assessment of the risks for workplace violence and harassment, and a review of your mitigating measures. So it might be that you might have to consider kind of where that person was with the student, if they shouldn't have been alone, or something like that. But once that review is done, then the process would end from our standpoint, because it's not an employee inflicting this incident on another employee.
Okay, I'm gonna add another layer. So sorry, I hope I'm not bothering other people either. But and then what about the scenario where, you know, it's, let's say, a child that has made a comment where the teacher heard and then, you know, reported it later on, and it would fall under you know, perhaps like gossiping or humiliating, you know, this other teacher. How would that, like, because, you know, and then there's a child, like, this is where like the complex, you know, comes behind this, because then you have the teacher that says, well, you got to do something about it. And it's like, well, yeah, but it's a child. So, you know, is he or she going to say the truth? They scared, you know what I mean? Like, it's,
Yes.
so in that perspective, we proceed because there's still, like, you know, the respondent that might have, you know, fall under that gossiping or, you know, whatever it is, where the complainant, the other teacher is like, I want action, I want, you know, and but then there's also the child involved in this. How would that differ in the scenario that you were talking prior to that?
So unfortunately, in this case, because it is not an employee doing that, or a representative from the employer, the protections are not the same.
Okay.
So we wouldn't still require that an investigation take place under the occupational health and safety legislation. Now, I'm not sure in terms of if there's requirements kind of through the school portion,
Right.
but under our section, it would still just be that review of the steps and mitigation that are in place to see if there's any holes that you identified because of whatever the incident was.
Yeah, and that might, like, that actually what I've seen so far and I've been exposed to is often when I come towards the resolution, it's really because, you know, I'm new to this role. So my predecessor didn't actually do any risk, you know, assessment. So what I'm finding is all these holes in how we're fixing them moving forward. So, okay, that answered that question. And I had one last one, sorry. That's okay. So you mentioned that you the courses, sorry, I was disturbed a little bit, so I apologize if you're repeating yourself. So you mentioned that, you know, you're responsible, or your team is responsible to facilitate, you know, workshop on workplace violence or lateral violence as well, or just?
So we include lateral violence within workplace violence and harassment.
Okay.
I usually specify both, because when I'm dealing with a lot of employers, they use that term almost as a separate type of violence, but under the legislation, it's all one.
Okay,
but we do offer these sessions, and also on any other topic that falls under the legislation. So we're the right price because we don't cost anything. So I always promote it, because I think that employers are often kind of afraid to invite the regulator to speak or to even kind of get involved with what's happening at the site. But if we're coming in that regard, we're not there to find violations or to do anything. We are there to help find a path forward and to give you the resources. So it's something that I think is really important, and we have employers taking us up on this all the time now, that they've kind of realized we can be not scary. We can be helpful.
Yeah, for sure, 100%. And then it's good to know, because I've worked a lot with the provincial health and safety department. So I'm glad I was able to connect with you on this session. So thank you so much. We'll be connecting later again.
I hope so.
That was all my questions.
Thank you. Okay.
All right. And were there any more questions from any of the other attendees prior to, I guess, me starting mine? Second delay. No, doesn't appear so. Well, there's the dialogue box, or you can turn on your camera, or, you know, those further north where it interrupts your internet, just turn on your microphone and let her go. we'll be happy to answer those questions. Just by way of quick introduction, my name is Joshua Sutherland, and I'm a lawyer at Harrison Company in Vancouver. Although that said, I am currently located in Alberta and transition back and forth between the two provinces, albeit I will be full-time in Vancouver here shortly. I myself am First Nations. I come from the Red Rock Indian Band on the Lake Helen Reserve in Northern Ontario, about an hour northeast of Thunder Bay. And but I'm very happy to be here presenting in this virtual world, and thank you all for allowing me to participate. My topic may not be as exciting as Melissa's and may not garner as many questions or interest, but nonetheless, I just wanted to quickly address a few changes to the Canada Labour Code that have come into effect that all should be aware of. And again, if you have any questions, please feel free to ask. The first and perhaps most on point for today, and Julia, if you don't mind going to the next slide, is I'll be discussing cultural leave, leave for victims of family violence. And I know, and I apologize, that we're probably all sick and tired of COVID-19 related discussions in general, but nonetheless, there's one important part about the COVID-19 in particular that I wanted to address. So we'll get to that, as well as flexible work arrangements, which I guess in the modern world, and particularly as a result of COVID, may be quite important to employers, particularly as the workforce starts to potentially come back as restrictions, depending on your jurisdiction, start to loosen. Julia, next slide, please. So the cultural leave. So the legislation defines Aboriginal as Indian, Inuit, or Métis. And if you are an Aboriginal employee who is federally regulated with at least 3 months of continuous employment, under the legislation, you are entitled to take up to 5 days of leave per calendar year. I suppose an important aspect of this is that it is presently unpaid leave. And in respect to the leave or the type of activities that is covered by the cultural leave is practices including fishing, hunting, harvesting, and any other practices prescribed by the regulation. Now, and I would assume that this would also extend into things like trap lines. And the reason why I highlight that or particularly focus on that is because my grandfather actually still runs a traditional trap line, and I thoroughly enjoy and probably learn more about life during the time that I spend with my grandfather on that trap line. And I would believe that it would also include cultural activities such as that. Now, you can take, or as an employee, or if any of your employees ask, the employer is required to grant that leave of up to 5 days in more than one period. So for example, they don't have to take it 5 days in a row. It can be 1 day here, 1 day there. However, it is required, or sorry, not required, it is permissible that as an employer, you do request that each period be taken in 1 day increments, such that they're not asking for 10 half days, for example. And if and so required by the employer, and there could be various circumstances in which this arises, although I guess we won't go into the various hypotheticals, but as an employer, you can request that the employee provide documentation that you are, or that the employee is in fact Aboriginal. And you may request this up to 15 days after that employee has returned to work. Now, again, the code does say that it is unpaid. However, like any aspect of the Canada Labour Code, you cannot contract below its minimum entitlements, but you are allowed to provide greater than the entitlements. So it would remain within the employer's prerogative should they decide to allow it to be paid leave. Julia, next slide. Just give me 1 second. I realized I closed my question or dialogue box, or at least I don't see anything popping up. So if you have a question and I accidentally ignore it, again, please turn on your microphone and interrupt me at any time. Leaves for victims of family violence. So who does it apply to and what does it encompass? So it applies to a victim of family violence. And there's no real definition outside of that in the code. But it also includes a parent of a child who is a victim of family violence. And the employee is entitled to take up to 10 days of leave per calendar year. And you're allowed to take that 10 days leave in any of the following circumstances, to engage in any of the following activities. So if it's to seek medical attention for the individual victim or the child who is a victim of family violence, it's for physical or psychological injury or disability to recover from it. It's to seek out or obtain organizational support or services from organizations that offer such support. So whether that be, a women's shelter, the Mustard Seed, or any other like agency. The leave can also apply to professional counseling, temporary or permanent relocation, should the circumstances be such that that's required. It's also to seek legal assistance or the assistance from legal agencies or otherwise, including criminal legal proceedings. So if there's a trial that results from the family violence, and then of course any other measure that is prescribed by the regulation. Now, similar to the cultural leave, these 10 days can be taken in more than one time. So it doesn't have to be 10 days in a row. It could be multiple one-day periods. And in terms of being paid or unpaid, you are entitled, or the employee is entitled, to take this sort of leave, that being victim of family violence, on day one. So as soon as they become employed, they're entitled to this legislative leave and its protections. However, it becomes unpaid, or it becomes paid if and when the employee has worked for the employer for 3 consecutive months. And once they have done that, the first 5 days of the leave is required by legislation to be paid. Pretty simple stuff in terms of what the legislation requires. But again, if there's any specific questions, do not hesitate to reach out. Now we'll quickly transition into the COVID-19 leaves. And that would be the next slide, Julia. This one is a little bit lengthier, but the very first thing I want to point out is the first bullet point there. And that is the COVID-19 leaves under the Canada Labour Code, as I understand it today, is that they are to be repealed on September 25th, 2021. And the slides I'm looking at say 202. Looks like yours do too, so I apologize for the typo. Might be a little outdated. In any event, there are 2 types of leaves or measures under the Canada Labour Code in respect to COVID-19, and that is a 4-week leave and a 42-week leave, and it depends on the circumstances in which you're addressing. Now, employees are entitled to 4 weeks of job protected unpaid leave, and you can take this leave as many times as necessary. If you are in one of the following situations, or if the employee is in one of the following situations, and that is they have contracted or may have contracted COVID-19, they have underlying conditions, they are currently undergoing treatments in respect to the underlying conditions and or COVID. They have contracted other sicknesses that, in the opinion of a medical practitioner, a nurse, a person in, authority. So I guess that could be a government health order or something to that effect, as well as perhaps an employer who suggests that they need to take time off as a result. And that is permitted, but again, is unpaid. Other situations is if the employee is directed to isolate, and that direction can come from the employer, or it can also come from the aforementioned practitioners, so medical, nurse, etc. Now, when it comes to the 42-week leave, an employee is entitled to 42 weeks of job protected unpaid leave again, if they are unable to work due to caring for a child who is under 12, as well as to provide care to a family member who requires supervised care. So 2 different subcategories within that 42-week period. And not too dissimilar to the 4-week period is that the protected leave is in respect to, again, a child under 12 or a family member who requires supervised care. Again, if they've contracted or might have contracted, underlying conditions, told to isolate, et cetera, et cetera. But as it relates to the child who is under 12, those exceptions for the unpaid leave of 42 or up to 42 weeks includes if their school or daycare closes, again, if they're required to isolate, or subject to medical opinion, there is a serious risk of health complications by attending school or daycare. And there is a final exemption, and it's escaping me for the moment. It is if the usual person who would take care of that individual or child is no longer available due to COVID-related reasons. Again, this is very similar to the family member who requires supervised care. It could be in the circumstances where the day program which they attend is temporarily unavailable for reasons related to COVID. Again, they're required to isolate, and if their care person is no longer available due to COVID-related reasons. So the 4 weeks relates to the employee, and the 42-week sessions relate more to the child and or family member. So a little bit of a distinction there. And again, where one is capped at 42 weeks and the other is 4-week increments, and there's presently no limit on it. But again, stay tuned to see if the federal government makes any more changes post September 25th of this year. If we don't mind going to the next slide. Something that I think will be a very hot topic, if it isn't already a hot topic in your workplace, is the federal government's efforts to create flexible work arrangements to bring greater, harmony in terms of work-life balance. And so I realize that there's only about 10 minutes left in the session in total, so I won't go through the entire materials that I had for this, because the flexible work arrangements is quite lengthy, but I'll try and hit some of the highlights. So again, the purpose of this amendment is to facilitate better work-life balance, and it applies to employees who have completed 6 months of continuous employment. And the workplace arrangements can cover a variety of different topics, and that is the location of work, such as working from home or a satellite location, the scheduling of working hours, such as modified work schedules or split work shifts, and of course the number of hours worked, such as going to part-time, to job shares, to reduced hours. Now, the right to request a flexible work arrangement again applies to someone who has been employed for 6 months or longer, and it can apply to, again, hours worked, work schedules, employee location, and even the type of compensation in some respects. And if the employee meets, these criteria as to what arrangements they're looking for, they will be entitled to an assessment from the employer. Now, that the request for a flexible work arrangement must come from the employee, and it must come in a written form. Now, when it comes to submitting, or I guess assessing the criteria, the employer, should be looking at to ensure that it specifies the name of the individual, it specifies the exact request that is being made, the date that the request is being made for, how long the period of the exemption or flexible work arrangement is to last, and a description as to exactly what arrangements are being sought. Now, my understanding is that under the Canada Labor Code, the employee doesn't just stop there. They also have to give a bit of an assessment or a prediction as to how this will affect the employer and its operations. Now, in response to any request, the employer has 30 days to make a decision. And under the code, that decision can be one of 4 possible responses, which again, must be in writing. And that is, they can approve the request as is, they can approve the request in part, or they can propose an alternative work arrangement. And fourth and finally, they must deny. They may deny. And if an employer does deny the request, it creates a little bit more obligation on the employer as to explain why. So more specifically, the employer must provide a justification as to why the request was denied. And they can, give various reasons, but some of those can include the requested change would result in additional costs that may be unduly harsh to the employer, or that will burden the employer. The requested change will have a negative impact on the quality or the quantity of work and the ability to meet client or customer demand. And it may or could potentially affect the performance of the employee's workforce or the workforce in general, et cetera, et cetera. And again, if you are an employer and if you are receiving this type of request, they can be a little bit difficult to navigate. So, don't hesitate to reach out to Melissa or myself for some guidance on it. But another, and I guess the final point to highlight on this particular slide, which will conclude the presentation, is that the legislation specifically states that there shall be no reprisal to the employee for making a flexible work arrangement request. So reprisal can mean anything from an adverse impact on their employment, whether that be through kind of explicit punishment, you're getting a demotion or a pay decrease, or it can actually work in the opposite. You are being denied a promotion or a pay increase. And then it can be a little bit more passive aggressive than that as well, such as just a general attitude change, not assigning as much work, et cetera, et cetera. And that can obviously be quite important if the workplace is built on commissions, or that forms part of their benefits package and or compensation package. So just be careful as to how the employee is treated post making such a request. And I guess it's the next slide, which just says questions. And then I guess, Julie, you can go to the final slide, which is, of course, just a thank you for allowing myself and Melissa to present to you today, and hopefully provide a little bit of guidance on these topics, and or if you've never been aware of them before, bringing them to your attention as to things that may become quite important in the workplace as we still navigate through COVID-19.
So we do have about 5 more minutes and then everybody will be automatically sent back to the main room. So we do have a couple minutes for questions. Just thought I'd say that.
And if there are no questions, I'm happy to talk about another hot topic, no pun intended, but the weather. Because I don't know if my microphone was interrupted or not, but it is spicy hot here in Calgary right now, and all the fans blowing on me hopefully did not come through the feed. It looks like we have a comment from Kaylee, which is more of a comment than a question, but thank you for that, Kaylee. And Kaylee, were you the one from Yukon? Yes, yes, she was. Well, I mean, I don't know, at least in Calgary, we get a little bit of reprieve because it's a bit of a dry heat here. So we get a bit of a reprieve when the sun goes down. But I don't know if that ever happens in the Yukon at this time of year.
Yeah, not really. It's light out a lot, and the bugs are vicious, vicious, vicious this summer too.
Holy mackerel. I mean, I must say the Yukon is probably one of my most desired places to go in Canada once these restrictions lift. So, but being from Northern Ontario, you know, particularly, or I don't know if you've ever had the chance to be up north of Thunder Bay, but if you fly over it, it looks like the entire landmass is under siege. There's just that much water, that many lakes. And with that much, with that much water mass and swamp and all of the rest of it, you know, boggy areas for moose, the bugs in in Ontario are pretty unbearable as well. I couldn't imagine what it's like in the Yukon. Guess they're aptly named horseflies for a reason. And to the extent that you're still there, where are the others calling in from, such as Valerie and Lisa?
Sorry, can you hear me?
Indeed.
Okay, I'm calling from Little Rock Nation in Montgomery. We're getting evacuated right now, so because of the flood. But otherwise, everything's good.
I think my in-laws' favorite winery is somewhere up in Lillooet.
Yes, yes, forbearance, really good.
Yes.
Yeah.
Cool. I drove that. Oh, looks like we're getting kicked out. But I drove the highway from Whistler up to Lillooet there about 1.5 years ago, and holy mackerel, that scared me.
Yeah, Duffy Lake Road is for adventurous people only, I think.
Yeah, it was good fun. It was good fun, but yeah, my first time doing it, I definitely took it slow, which is nice because then you can take in the scenery.
I know, it's outstanding for the views, that's for sure.
Okay, well, I think we're going to get kicked out here. Melissa, so nice to meet you. Thank you for allowing me to present with you. And Elsa, Julia, thank you for the opportunity. And for those who listened, thank you so kindly.
Thank you, everyone.
Thanks so much, everybody. See you back in the main room.